The background which my Lord seems to have is nationalization. His whole focus was, when I nationalize, I can take private property and nationalize it. That seems to be the focus. It is in this context that the phrase has been used there. This is my humble submission, my lords. I can't leave out what Justice Krishna has said, dehorse what was in his mind. So, my lords, may permit me to go further. My lords, may please see para 41. If the state to subserve the objects of governmental or other like agencies compulsorily takes movable property or reality of private citizens, the like of which are readily available in the open market, does the law authorizing such violate the limitation of public purpose imposed by Article 31(2) of the Constitution? Today, my lords, I can't go further on this because I don't have Article 31(2) on my statute today. But yet, the underlying principle seems to be nationalization, as I pointed out earlier. Throughout, even in this paragraph, my lord, the lordship is concerned with nationalization. It is in that context, again I re-emphasize, my lord, it is in that context that that phrase finds place in Justice Krishna's judgment. Not that 39B, not that in 39B private property would be included. No, it says you take private property for nationalization. There in that context, it says distribution of such property would be for the common good because I'm giving it to the public at large. I'm taking from one person and giving it to the public at large. It is not a case where a private property will be taken and given to another private person. That is not what he had in mind. My Lord Justice Krishna had nationalization only in mind when he made this submissions. This is my humble submission for your Lordship's kind consideration. But take my Lordship still further. Where my Lord deals with distribution also. My Lord says distributed. There also my Lord says that is the basis of 39B. Distribution for the common good again means nationalize and give it to the people. Don't keep it with you. Give it to the people. Throughout, give it to the people. That is his whole focus. With this background in mind, my lords, I may kindly be permitted to now read the provisions of Article 39. But before I go to 39, a few other articles which might throw some light on the interpretational process.
Mr. Devaraja,
yes, sir.
Perhaps you will also take us on the objective of the Act, because after all, we'll have to consider, together with what you are trying to canvass before us, that it is only in the context of nationalization, because the Act obviously doesn't think of nationalization, but it talks about giving it back to a community or a let us say cooperative society. So therefore, you'll have to take us through the objective of the Act as well.
This Nationalization Act or our Act?
The MADA Act.
MADA Act. Please, my lords. I was avoiding it, my lords, because in between it came from your lordship that the lordships would prefer to deal with this.
Don't get derailed.
Sorry.
We'll have to understand the context of the Act.
Yes. Please, my lords. I will, with your lordship's kind permission, I'll take your lordships through the provisions of the statute also. But what is its purpose? I may tell your lordships in brief. The purpose of Chapter 8A of the Act is preservation of inverted commas. I'll set out those provisions because I've got a note which I'll hand over. Each section I have analyzed, I'll put it. Before that, my lords may kindly permit me to just clear this small aspect which was there in my mind, which I thought I would share with your lordships, and namely about material resources. I don't want to go into material resources per se. I already made a submission to your lordships that I have to read 39 in the context in which it was placed in the statute book. And the context is what? The context is, it's a directive principle to the state. To do what? 37 very clearly says, shall be the duty of the state to apply these principles in making laws. And now in that context, when I come to 39B, well, let's have 39B for a moment, please. Thank you. Thank you. Well, would your lordships have 39B for a moment, please?
Yes.
Yes. My lords, my submission here is, if the term material resources of the community is to include private property, if it is to include private property, then some words have to be added, or some words have to be deleted. Namely, here, my lords, the ownership and control of private material resources of the community are so distributed. Private has to be added there, or what they should remove is material resources are so distributed of the community has to be removed. If it is removed, then this material resource will apply to all resources, private and public. We are asking ourselves to read this article, which has got drastic consequences of shutting out my constitutional rights under Article 14 and 19 in a manner which is not present in that article.
The term community, it will not be included.
Community is not defined, but I take it that community means the entire, whoever is, what should I say, affected by, or a particular, like we say, the Pavilion community, the Andhra community.
Private also. Community means it's a generic term basically used.
Correct. But when I talk of the resources, I'm now talking of the resources also. And here, my lords, sorry, my lords is saying something.
Of the community.
Bharat cooking.
Are you trying to say that resources of the community, material resources of the community does not encompass private resources?
This is what I am trying to submit, my lady. For the reason that if it were so, it would read private material resources of the community also. Because as my lordship said, every individual is a member of the community. There's no doubt about it.
Talks about resources of the community only.
As that's this point I'm trying to say, trying to canvass for your lordship's kind consideration is, if it was intended to cover private resources, the 39B could have specified it. Rather than leave it for an interpretation to somebody who could misinterpret it or interpret it in a different way. It's just an addition of a single word or deletion of certain words. Here, my lords, I will take your lordships through one judgment, which I could lay my hands on, where the term material resources has been considered. Apart their lordships have said. Where is that?
Yeah, for a cooking relevant portion 2-3
Okay. In that judgment compilation, what was that, volume 5?
Yeah, volume 5.
Volume 5, my lords could have page 2314 for a moment, my lords.
1983, 1 ICC 146. Page 2.
Okay. Trouble my lordships to have a look at that judgment, please.
Yes.
My lords, in Sanjeev Coke, though it's against me on other aspects, my lords, one very important factor was considered.
But in Justice Krishna's judgment, just read para 80 and 81.
Please.
Justice Krishna links it with the whole concept of redistribution
Correct.
and says that the focus of Article 39B is on redistribution. Then whether that material resource is public or private should not make any difference. That's the logic of his judgment.
Essentially, my lord, that is nationalization concept, my lords. If I read this again in the
para 80 and 81, you can read.
Yeah.
1771.
Yeah, my lords, 1771.
17 what?
1770, 1771.
Right. This was the one that-
Yeah, please, my lords. My lords, reading para 81, my lords. My lords, could I read para 81, please?
Sorry?
Could I read para 81 onwards, my lords?
You can actually read para 80 as well.
Please, my lords. This takes us to the non-negotiable minimum of nexus between the purpose of acquisition and Article 39B. 39C was feebly mentioned in Article 39B, was forcefully pressed by the appellant. Better read 39B before discussing the full import. Certain principles of policy to be followed by the state. The state shall, in particular, direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. The key word is distribute, and the genius of the article, if we may say so, cannot but be given full play as it fulfills the basic purpose of restructuring the economic order. Each word in this article has a strategic role and the whole article a social mission. It embraces the entire material resources of the community. Its task is to distribute such resources. Its goal is to undertake distribution as best to subserve the common good. It reorganizes such distribution, by such distribution, the ownership and control. Resources is a sweeping expression and covers not only cash resources, but in availability to borrow credit resources. Its meaning given in black, so my lords go through it. Now, just take your lordship next. And materials of the community in the context of reordering the national economy embraces all the national wealth. My lordships, Justice Krishna here would like to even take away my salary or my fees and distribute it. I'm not saying anything about anybody else, but at least for myself, I can say, if what Justice Krishna says here is implemented, whatever fees I earned also can be taken away and distributed.
They do that in tax.
They did it in the past, my lords.
97% was the tax at one time.
They did it in the past, my lords. They say you earn 3,000 rupees. If you earn 3,000 rupees, if your DA goes up by 1,800 rupees, we'll reduce your salary and keep it 3,000 rupees. They did it in the past, my lords. So all the time trying to suggest, my lords, again, reading this para also, my lords, it takes me back to the same principle. The same principle he wants to usher in a socialistic pattern of society.
One of the aims of that is with regard to concentration of wealth in the hands of a few. So in that context, nationalization was one of the vehicles to see that such a thing did not happen
Correct.
in society.
So, my lady,
Distribution of wealth.
my lady, taking what you file from my ladyship's a little further, would taking away from one person fall within that category? Would taking away a private person's property fall within that category? Is a question I am asking myself, my.
Agrarian reform is based on.
I'm not taking my losses through para 82 because he categorically deals with nationalization and says it has a nexus with distribution. I have no issue. I'm not going into that.
This is not national.
Now, since my lords would like me to take your lordships through the act in question, where protection of 31C is sought by the state and which we feel they cannot have, I may broadly tell your lordships what that chapter is. Broadly, I'll tell your lordships.
81 also.
Sorry, para 81. Please, my lords. My lord has got it. It's at page 1771 of the compilation. Resources is a sweeping expression and covers not only cash resources, but even ability to borrow. And material resources of the community in the context of reordering the national economy embraces all the national wealth, not merely natural resources, all the private and public resources of meeting material needs, not merely public possessions. Everything of a value or use in the material world is material resource, and the individual being a member of the community, his resources are part of those of the community. Now, Should be bar and cooking.
Yeah.
This is a constitution.
So land,
So this the first
Land.
page.
any land in excess of the ceiling that was taken away, it vested with the state for the purpose of redistribution.
Yes,
And that is private land.
true. True. My lady were taken away under what provision of the act? Under what provisions? And in respect of what?
Land Reforms Act.
Correct. Land Reforms Act, my lady, we have specific provision, Article 31A, which deals with estates. There they don't rely on 39B at all. They don't rely on 39B at all. I could, what falls from a ladyship, yes, I did think about it, but then they don't. They don't say, I pass an act and seek protection elsewhere. 39A itself says, if it's an estate, yes, I can take it away. Because the whole concept of 13A is Zamindar system to abolish Zamindar system. Large tracts of land, they wanted to give it to the tiller. Land to the tiller was a concept those days. Today they are saying land to the tenant. Even if the landlord has got a single building, even if he's surviving with a meager rent, you take it away from him. Today, my lady, my kindly let me, what Justice Krishna has said about material resources, a subsequent bench has clarified what material resources. Give me Bharat cooking.
This is the string.
Constitution bench in Sanjeev Coke. That judgment is against me so far as 31C is concerned. My lord.
Sanjeev Coke now?
Yes, Sanjeev Coke, Manufacturing Company, 1983, 1 SCC 147. My lord, it's at page 2294 of this case law compilation. My lords. It starts from there.
22. Yeah. Relevant portion is 2314.
Yes. The relevant portion is para 19 at
2314.
2314, my lords. Sorry, the judgment starts where? My lord, the judgment starts.
2313.
Huh? Sorry, my lord.
19 is 2313.
Yeah, but relevant portion is yeah.
It's, my lord, it's para 19, but the relevant portion is on the next page, my lords. 2313 is where it starts. 2314 is the relevant portion, my lords. May permit me to read it, my lords. The expression material, I'm sorry,
Where you are reading?
my lords, after the starting of the page, the lordships are dealing with state of Karnataka with Rangnath Reddy on the top. And about say 8 lines below, my lord. 8 lines below.
Is it part of paragraph 19?
Yes.
Yes, my lord. Paragraph 19, part of paragraph 19. my lord. Unfortunately, I don't see the placitums here, which were there in the past.
Sen.
Yeah.
Sen.
The third line, read from the third line.
Yes.
She sent
She said urged that if the word distribute was given its proper emphasis, it would inevitably follow that material resources must belong to the community as a whole. That is to say, to the state or the public before they could be distributed as best to subserve the common good. Since these material resources which belong to the state only could be distributed to the state, Sri Sen argued that material resources had first to be acquired by the state before they could be distributed. A law providing for acquisition was not a law for distribution. Okay, this is important, my lords, where they say, we are unable to appreciate the substance of Sri Sen. The expression material resources of the community, now they have defined this, my lords, of the community means all things which are capable of producing wealth for the community, not that all things in which the community has an interest. No, They say that must produce wealth for the community. Then it will be a material resource of the community. Here, so this is the test, my lords. Is this a material resource or not? The test is, would that resource produce wealth for the community? Not for myself. This is the test that your lordships have laid down. And then they say, there's no warrant for interpreting the expression in so narrow fashion as suggested by Sri Sir. I'm not going further, my lord. For my limited purpose, my lords, material resource means it must produce wealth for the community. Like the buses did. In a nationalized program, those buses did. Whether they actually earned or not is a different matter, but that was the intention. So, yeah, I finished this 39.
B refers to material resources of the community, does not refer only to resources owned by the community as a whole, but it also refers to resources owned by individual members of the community. That's what they say at page 2315.
Please, my lords. No, this is the point that I am trying to say.
Resources of the community do not mean public resources, but only, but include private resources as well.
The point that I'm just emphasizing a little more. Yes, private resources, but for what purpose? Producing goods and services for the community. If I have a piece of land which is just lying there, you take it and produce goods and services for the community. There's no difficulty in 39B applying there. The crucial word, according to me, is that, my lords, this is emphasized by the interpretation of 39B. So since, my lords, it will be necessary for us to see what this chapter 8A is about, my lords may permit me to just place it, my lords. Give me the act. Give me the act. No, give me the act. Broadly indicate, my lords.
Page 398.
My lords, where I don't want this. This is a better. sorry, my lords. Keep it just. My lords, I had circulated one note which reads history regarding repairs. Could I take a lordship through that note, my lord?
Yes, certainly. Where is that?
You can't have one, please. My instructions are it was made to your lordship this morning, my lords.
Just be uploaded for us. Here.
Serial number 6, history repairs. It's open. Number 6. There.
Okay.
Actually, we should go to the act
Yes, sir.
more than the note. We'll look at your note, but let's look at the provisions of the act
Please, my lord.
of chapter 8A.
Yes.
And because they will give us a flavor of whether these provisions have a nexus of the distribution of the resources of the community for the common good.
Please, my lords, I will do that. Mera note on 38. My lords, the reason why I suggested this is, in this note, my lords, if your lordships kindly go to a little down, I have set out the salient provisions of the Act, my lords. At 12, my lords. At item 12,
Mr. Devarajan is the only councillor now who has to argue on this side.
my
Right?
lord, small request, my lord. My learned friend might add a few things to what I have said. Few things he might like to add, and my learned friend Jal also might like to add a few things. Just a few things.
So, Mr. Devarajan, you can wrap up by 3:30, about 50 minutes.
I'll try to wrap up. I'll try to wrap up as fast as
So
possible,
that
my lords.
by 4 o'clock, we'll complete this side.
I'll
Then
try.
Tomorrow we'll
My
start.
lords
with the
may
other.
kindly give me a leeway of about 10-15 minutes, given my speed is not that
No,
good.
no, no problem. But by 3, that's why instead of 3:15.
I will try, my lords. I will definitely try to obey your lordship's directions.
4 o'clock, then we
Okay.
call upon the other side tomorrow.
Okay. My lords, if your lordships, just to shorten the things, in this note, my lord, serial number 12. In this note, serial number 12, I've set out a salient factors of chapter 8A, but I need to take your lordship through the whereas clauses also, which I would do subsequently. But now let me take your lordship to chapter 8A, because this will directly answer the question that has been posed to me. My case is, my lords, that chapter 8A, in its pith and substance, is for preservation of housing stock. These old buildings, how do I preserve them?
Not just preserve them, but actually reconstruct them as well.
So that's why I will take your lordship through the section 103B. It will become very clear. They use the word better preservation or reconstruction. The emphasis first on better preservation, my lords. So my lords may permit me to just take your lordship briefly through this note, and then I'll take your lordship through the sections.
Which is the chapter?
Chapter 8A.
What is the page, the PDF page?
Chapter 8 is 4033 of the main statute. compilation.
No, we have
4033.
7 of the new compilation.
But the new
Yes.
compilation is to the-
My lord, my lord, we put the gazetted copy today, man.
We've got chapter 7A now.
8A.
At 4033, we'll go to chapter 8A.
8A, my lords.
7A is not in question here. Right?
Actually, my lords, there was no 7A at all.
That's a typo
There was a typo, my lords.
in the SEC.
Absolute typo, my lords.
3A is in chapter 8 or 8A?
At 8A, my lords. If you, my lordship may kindly see
Their
today's.
concentration is
what they have-
on 8A. Chapter 8A
What
is the,
PDF page? We're just trying to.
4033 is 8A.
So 103A is in chapter 8A.
Please, it starts from there.
Because the title says chapter 7A, that's why I asked. It's a typographical.
Typographical. My lords, today we've uploaded a gazetted copy of the act, my lords. In that, lordships will find it page 237, chapter
okay.
8A.
Typo.
I'm told it's a typo, my learned friend told me this.
it is,
The type.
it is 8A.
It's
8A.
8A actually.
4033 in which volume?
Volume
Volume 4.
Volume 4.
Volume 4. No?
He's comfortable.
My lords, could I trouble your lordships to look at the gazetted copy, because there might be certain.
No, it will be the same. That only changes that chapter 7A.
No, as I said, I've not cross-verified, so I'm requesting.
You read the gazetted copy. If there's some change here, we'll know.
All right, my lords. My lords, please see section 103A first.
Yeah.
Section 103A.
Bhagya.
Okay.
Yeah, I don't know.
Section 103A states, my lords, that the chapter will apply to all buildings constructed prior to 1st September 1940. The proviso to that says two things. One, it says that the buildings should be predominantly residential. That is, more than 50% of the occupants must use it for residential purposes. That's the first point, my lords. The second point is, it should be a building belonging to category A. That is to say, other buildings are not part of chapter 8A.
It's defined in section 84.
Chapter 8A is defined in chapter 8 under the heading for.
And it's category A is in section 84 at page 4023.
Correct, of the of chapter 8. Briefly put, my lords, the categorization was done like this, my lords. Buildings constructed prior to 1st September 1940 are category A. Buildings constructed from 1st September 80 till 31st December 1950 are category B. And buildings constructed from 1st January 1951 till the enactment of the Cess Act. There used to be a Cess Act before, my lords, called the Bombay Buildings Repair and Reconstruction Board Act, 1968. That till then, my lord, all those buildings were categorized as category C, and cess was being levied depending upon the category of building. That's in short, my lords. Here, my lords, may please see the first provision to section 103A. Provided that nothing in this chapter shall apply to any such building belonging to category A, if on the commencement of the MADA Second Amendment Act 1986, out of the total number of occupiers of such building, 50% or more occupiers are using the tenements or premises in that position for commercial or non-residential. In other words, my lord, even though cess could be levied on a category A building, these buildings, where it's predominantly commercial, would not fall within the provisions of chapter 8A. Then we come to the explanation, my lords. We are today, for our present purpose, my lord, explanation is not that relevant. What is relevant is 103B. 103B says, notwithstanding anything contained in chapter 8 or any other law, a cooperative society formed or proposed to be formed by under the provisions of the Cooperative Society Act, but not less than 70%. I would stop here for why I'm saying this 70%, my lords, is when I deal with 39B and the policy. When I deal with the policy and 39B, the policy of the state and 39B, what is the correlation between this act and the policy? If there is a policy, it should apply to everyone. Now, this act is doing two things. It's not dealing with all pre-1940 buildings. That means to say it's not dealing with all dilapidated or old buildings which they consider to be dilapidated. It is only dealing with certain old buildings, whatever be their condition. That's the first part. The second point, as I said, is the trigger is 70% people wanting it. And what do they want? And why do they want it? They want it for one purpose. They say, my lords, may please see, they make an application, they make a written application requesting the board to move the state government to acquire the land. For what purpose? This is important, my lords. So go just a few also. They 4 lines below that section, my lords. In the interest of its better preservation, my lords have got that. In its better preservation or reconstruction of a new building in lieu of the old one, and intimate their willingness to pay the amount of such acquisition as may be determined under the provisions chapter, and to carry out the necessary structural or other repairs or wherever necessary. My lords, may please see, the reconstruction is wherever necessary to reconstruct a new building. I ask myself this question, Is this not a provision which deals with preservation of housing stock? If it's for preservation of housing stock, how are they referring it to 39B? Because one of the tests that your lordship have time and again said, we will see whether there's a nexus between 39B and the enactment. Here, I ask myself this question.
No, it has a nexus with distribution because what happens is that instead in place of the ownership of the erstwhile owner, the property upon acquisition vests in a cooperative society. And that cooperative society represents the interests of all the occupiers. So as opposed to the property being concentrated in the hand of the owner, as a result of this acquisition, title is transferred to a cooperative society, provided 70% of the occupiers want to come together and form the society and express a willingness to pay the amount of the compensation for acquisition.
If what your lordship said was the act,
idea is for the better preservation of the building, or if repairs are required, repairs, or where reconstruction is required, reconstruction.
so the small aspect which I'd request your lordship to consider is there a transfer of ownership at all? Is there a transfer of control at all? Section 103C will explain this. Section 103C will explain the concept of what am I giving a cooperative society? Am I transferring ownership to him? Am I giving control to him? 103C will explain.
Now just see before 103C,
Yes.
subsection 2 of 103, 103A. This is 103A, no? Yeah, B. On receipt of the application under subsection C, under subsection 1, the board shall, after due verification and scrutiny, approve the proposal if it considers that it is in the interest of the better preservation of the building or it is necessary for reconstruction of a new building, and shall direct the cooperative society, whether registered or proposed,
To pay the
deposit with the board within a period specified by it in that behalf 30% of the approximate amount that would be required to be paid to the owner if the land is acquired, and give intimation that behalf.
My lord, in
security
short,
put up front.
my lord, in short, that is the second part of our submission. In short, my lord, this act says, you pay the entire money of acquisition also, because 103B itself says so. You have to say that I will not only pay the cost of acquisition, but I'll also take care of the cost of repairs and reconstruction if any. If the entire money is to be paid by a private individual and the state does not have to shell out a single pie from its coffer, would this be a concept of public purpose? And 39B has to be for public purpose because every action of the state has to be in furtherance of public purpose. This is what your lordships have said time and again.
The public purpose really is the better preservation of dilapidated buildings.
Yes.
The reconstruction where reconstruction is necessary. Because reconstruction is in order to obviate a danger of collapse and a loss
Saving
of
human lives.
And though the state does not pay the state carries out the entire acquisition. But since it's in the interest of the cooperative society, the amount has to be deposited by the cooperative society with the board.
They have to pay the entire cost, my lords. They have to pay the entire cost. They have to pay the entire cost. And way back, my lords, not today. In Kasturi's case, long ago.
Mr. Devarajan, we are not looking at the constitutional validity of the statutory provisions.
No, we are not. We are looking at it vis-a-vis 39B. No, my lords, I'm also making submissions vis-a-vis 39B because to me, 39B has to be for a public purpose. Well, please, my lords, it has to be for a public purpose and it is in public interest that 39B has been inserted. Sans that 39B would have no sanctity, my lords. A directive principle to a state has to have a public interest and a public purpose, my lords. 39B can't be read dehorse these things. This is something, my lord, my voice is a little loud, but I don't mean any disrespect to the bench. I don't mean it, my lords.
very frequent visitor to the Supreme Court.
My lord, I was practicing here till I reached a stage where I could not walk, my lord. Even today, I'm standing with great difficulty.
Oh, we are.
I've got a hip bone replaced, my lords. I could not walk. I could not stand the winter. And so I had to migrate back to Bombay from where I started my life.
But decibels here are astounding. That's what I was going
I'm
to
sorry,
say.
my lords.
Decibels here are astounding of some of your colleagues in the bar.
Especially on miscellaneous days.
Even if some lawyers are appearing virtually and they are on a mute mode, we can hear them.
Sir, I could say the same about you also, sir. I've been hearing you frequently, sir. I'm sorry, no offense meant, sir. No offense meant, no offense meant. Sir, if I may continue, sir. So this act, we are not, sir, again, I'm saying, I'm on the question of control. We are not checking the validity of this act, only trying to explain what are its content, and we are going to see whether 39B can at all apply. We are not going to the validity of the act because I got other challenges to challenge this provision. I'm not on that. I am saying concept of distribution of control. Who has got the control? If I see 103C, the control is with the board, not with the society. If that society is given, it has to use it after reconstruction or repair for the same purpose for which it was using before. So where is the distribution? Where did you transfer the control? Secondly, my lords, if by chance one of the members disposes it off, immediately, my lord, that transaction is void, and the board will have a right to take back the property. Where is the transfer of ownership? These are the questions that are falling from the provisions of this act, my lord. So when I test this act, either on the basis that there should be a transfer of ownership or control, I don't find a transfer of ownership or control.
Why?
Because
Ownership and control is transferred to the cooperative society.
my lords, one of the incidents of transfer of ownership would have the absolute right to the property. I don't have.
I mean to the cooperative society.
I don't have a right, my lord, because they say the moment I gift it, my lord, if I read section 103C, then your lordships would see how drastic that provision is. If that occupant gifts it, that gift is void. The property can be resumed. If the society uses this property other than what it was using before it was acquired, again they will resume. Where is the transfer of ownership then? If at every stage, whatever I do, you are going to have it, you have the absolute control over it.
Yes, after the land is transferred to the cooperative society.
Even then, my lords, that is what I'm trying to.
And subsection 7 of 103B says, subject to the provisions of subsection 6, the authority shall convey the land acquired under this section to the cooperative society of the occupiers thereof,
Exactly.
with its right, title, and interest therein, and execute without undue delay the necessary documents. Therefore, title is transferred to the cooperative society.
Yes. There they say, I will transfer the title. But now let me see what 103C says. Let's see what 103C says. The transfer of title is subject to the conditions contained in 103C. 103C starting point. It says, after the land is transferred to a cooperative society, my lords, may please kindly allow me to place this a little more forcefully. He says, after the land is transferred to the cooperative society, under subsection 7 of section 103B, which my lord the Chief Justice just now mentioned, what happens? The society shall use the same for the purpose for which it was used before the acquisition.
You can make it in
So,
commercial.
log on usage.
No, it's not a clog on usage. The idea is that, look, if it was for.
My lord, if I am the owner,
Converted into a five-star hotel.
Commercial.
lordship,
Converted into a five-star hotel. The idea is to protect the occupier.
no. See, no, they are not even protecting the occupier. That's the unfortunate part of it. If they protect the occupier, my decibel levels would have been very, very low. They are not. They are saying that go further, my lord, see. And if no member or tenant of the cooperative society shall transfer his interest in any tenement by sale, gift, exchange, leave or license, assignment, what is this? I mean, I don't have any of the incidents of ownership. I can't even gift it. And yet, there is a transfer of ownership to me. If this is the law, my lords, then I have to bow my head. I have nothing else to say on this. Okay. We'll take him to that only. To sit.
That. We all wish you a very happy
No,
birthday.
no, I said that
No,
the
my-
court is very kind if you
So
want
the
to sit
learned
and
solicitor was
argue, then
suggesting to me that I should sit.
If at any point of time you want to sit and argue, please feel free.
that's all, that's
My
right.
lord,
The
it will
court is
make me
always
feel
kind.
sicker than I really am. I walk with a walking stick. Today I said, no, I'm not going to carry the walking stick. Let me walk without a stick.
Should not do that.
And that's all. Because I have 3 people to hold my hand. Why should I need a walking stick for that? No, sorry, jokes apart, my lord. Come back again. My lord, I'll come back again. So, my lord, 103C.
सिमरन का भी तो report
C, subsection 2 is a little this thing.
is for
It says, save as otherwise expressly provided in this chapter and notwithstanding anything contained in any law for the time being in force. You cannot do this. But see the embargo, man. The embargo in 103C2 and then sub 3. If a corporate search contravenes the provision subsection 1, out. It will go back.
But Mr. Devarajan, see, 103 itself says that it will be used for the same purpose for which it was used prior to this particular state.
Correct. So
So
therefore,
so far as the occupants are concerned, their occupancy right in that building, whichever way it comes up thereafter, is protected. So it is to protect the right of residents.
could I make a small submission here, my lords? These are all people who are protected by the rent control legislation. Nobody can touch them or turn them out except by filing a suit in the rent court. Most of them have been living, and as my learned friend pointed out, there are people who are claiming tenancy rights in the state, in the city of Bombay, and practicing here. I don't take anybody's name. They are paying peanuts, my lords, for the huge premises that they are staying. So therefore, my only submission here is their occupancy rights are sufficiently protected by the provisions of the Rent Control Act.
Eviction, ejectment, etc.
To just swiftly respond to what your lordship says. My lord, I'm saying it extempo. Sorry.
and the responsibility then
CJI after 1960.
My Lordship's kind permission, can I take a sip of water, please? Obliged, my lords.
So what is the next provision you want us to see, Mr. Devara?
My lords, I just want to point out one more thing. For a long time, it was in my mind that what's wrong? If the landlord is unable to maintain the premises, then what's wrong in getting the tenants to do it? To this, my lords, I found two problems to that question. One is, there was a provision under the old Rent Act and probably even in this Act, my lord, that if the landlord is not, because earlier, the lordships would be aware, earlier the landlord could increase the rent after carrying out repairs. Even if he doesn't have money, he could borrow money and carry out repairs, and the tenant would repay that amount in pieces. Then they came out with an amendment saying that if the landlord is unable to do it, you carry out the repairs. And then you deduct it from the rent that you have to pay to him. All this not having worked, in 1968, they come out with an act called the Repairs Board Act, the Bombay Repairs and Reconstruction Board Act 1968, where they said, this board will carry out the structural repairs, you pay a cess, a tax is levied for carrying out those repairs. Even that they did not do. And today, in 86, they come out and say, these buildings are not being looked after by you. They forget that they have taken the responsibility to carry out the repairs. They forget that they are taking money from the people for carrying out the repairs. If they have not carried out the repairs, today, they say in this act, if it's a lordship should see, this act, they seek to now, we might have committed default, we might have frozen your rents at 1940 levels, we may not have made it possible for you to carry out repairs, yet buildings have gone bad, so we will take property from you. Now, whether at all 39B envisages such a situation is a question which I request your lordship to kindly consider. I'm a tenant myself, my lords, but still I'm fighting for a landlord's just demand. That please don't deprive me of the property that my forefathers have brought into. And my lords would be aware that when the Cess Act came, there was a challenge done. And the report was recorded as to what is the status. This particular thing is for only seven wards in the Bombay. But they're all old buildings, no doubt. But what is the remedy? Is it taking it away? Why not create conditions to make them carry out the repairs? And if they don't, then you take it away. This is all I say. You do whatever you want, but please make it possible for them. You don't say that I will take it, I will carry out the repairs, you pay me the cess. And at the end of the day, you say that I could not do it, so you give me the money, give me the building to the tenants. So tenants are given an opportunity, they don't do it. Board says that they will carry out repairs, they charge the cess from the tenants as well as from me. And at the end of the day, the building is in a bad condition. Who is responsible for that? I ask myself this question. Rents, it is now recorded, my lords, that cost of building materials have gone up substantially since 1940. Astronomically, my rent is for. If anything in the world has remained stagnant and steady, it is the rent of these landlords. That's an argument for the Rent Act, my lords. I'm not on that. But I'm on whether at all 39B envisages this. If 39B is supposed to do equitable distribution, where is the equity in this matter? This is the question I'm asking myself, my lord. My lords, I won't stretch, my time is coming to an end. I have lots more to say, but I'll request my learned friend to continue, my lords. My lords, can I be thankful to your lordships for their kindness?
Thank you, Mr.
Yeah.
Yes, Mr. Farid.
Achha, so I'll attempt to answer the questions that have come from the bench. And first, my lords, let me answer on the interpretation of Article 39B. And my lords, the moment we consider the place in which this article appears, the interpretation is quite evident. And in fact, the Ranganath Reddy judgment itself explains why they specifically said that we are not endorsing what Justice Krishna Iyer said. And let me just indicate why. 29B is one of the duties of the states. It's not one of the powers. And that's one of the answer to my lord's question. Does 29B, if my lords interprets it, Article 29B, Article 39B, my lords interprets it narrowly, does it impact the power of the state to acquire, say, the coal mines or land or other properties? Now, Ranganath Reddy itself answers, and therefore let me just put it in this manner. There are three different sets of provisions in the Constitution. First is Article 245 onwards, which are the legislative power of the state, which include the power to acquire land. And as Ranganath Reddy says, that seen with the concept of eminent domain, power to acquire land, etc., is all covered in the legislative power of the state. So therefore, whether 39B exists or not in the Constitution, the power to acquire land, give it away, etc., is all part of 245 onwards, the legislative powers of the government, the union and the state. Now, what are the principles that are to be followed? Again, Ranganath Reddy records that it must be a public purpose. So if suppose in that case, it was transport permits were acquired, fair compensation was given. The court said that certainly the state has the power to acquire transport permit. The only test is compensation, public purpose. If these two tests are met, we approve the act. There is no difficulty with the act. We don't have to touch 31C. The act is valid as it is. 39BC and are therefore irrelevant. And that's what the majority says in Ranganath Reddy. Now, therefore, we now come to the two parts, namely part 3 and part 4. What are these parts and how do you interpret? And what is the principle that my lords will consider while interpreting these provisions? Article 3 is a fetter on the power of the state. My lords are, of course, familiar. I'm not going to expound on that. Part 4 is a duty of the state, and therefore 37 onwards starts with what are your duties. First, it defines the state. Who is the state? What are the powers? What are the duties? Now, once my lords considers holistically the provisions of Part 4, it would be evident that Part 4, 39B, is a duty of the state to use material resources of the community for the benefit. Let me just read that. To subserve the common goods. Now, seen as a duty, the only meaning, my humble submission is, that you can ascribe to 39B is that when there is ownership and control of material resources of the community, community can be state, a body under the state like the MADA, the Panchayat and various other bodies, and those Panchayat, etc. are also provided herein. You have a duty to use the goods or material resources of the community to subserve the common good. It's a duty of the state. So do not use the material resource of the community not to subserve the common good. It stands to reason. And therefore, 39B is a very limited provision which requires the state to act in a manner to subserve the common good. And therefore, our humble submission is that when you read and why the words of the community are used is very crucial in interpreting 39B. Because otherwise, it would have simply stated that material resources should be distributed to serve the common good. It doesn't say that. It says ownership and control of the material resource of the community. It must necessarily mean, in our humble submission, resources which are controlled by the state in some manner, which will serve the common good. And of course, we leave aside 31C for the moment. This is the only consistent interpretation that can be given to 39B. Therefore, we are on both paths. First, it should be, and then I'll come to the touch upon the act also. There should be ownership and control of material resources. I do not want to dispute that a house is a material resource, no difficulty with that. But therefore, is it a material resource of the community for the purposes of Article 39? In some other context, maybe, certainly. In a context, you may say that the housing is part of the community's assets, no difficulty. But when you are casting a duty on the state that use the resources of the community for common good, what are you trying to imply or mean is the submission that I'm seeking to make. And it can only mean goods controlled by state in some manner, directly, indirectly, etc. And that also follows, therefore, and therefore what Justice Krishna here and Mr. Devarajan therefore was rightly pointing out, that if you construe it in this manner to say that 39B will also apply to private goods, then you are what, in fact, Justice Krishna does advocate is that please acquire private property and distribute it. Now that is too extreme a view in my humble submission. It's a too extreme, it's a Marxist concept that you acquire everybody's land and give it to everybody else. That is not, in our humble submission, the intent of 39B. It cannot be interpreted in that manner. The duty being cast on the state is not that go and acquire everybody's private property and give it to everybody else. That's not, in our humble submission, what 39B is seeking to achieve.
One of the public purposes under the Land Acquisition Act
Lordships.
to give the to acquire land and give it to the persons who do not have a site.
Absolutely.
Those who are landless, in the sense to give them a house.
I am grateful, and therefore Ranganath Reddy says for that you don't need 31C, 31B, 31A, you don't need 39B and C. That is inherent in eminent domain doctrine, because you can acquire land only for public purpose. If you acquire land, you acquire a coal mine, you acquire an estate, a jamindari, give it to the tiller, that's your power under 245. Nobody can take it away. In fact,
according to material resources of the community must mean resources which are controlled by the state.
I am deeply obliged, and that is the only meaning.
Private property.
That only meaning that would make sense, because if you forget 31C, capital C for a moment, that's the only logical meaning that you can ascribe to 39B, which is the duty of the state. The duty of the state is use your resources for public good. It is not to say that you please go and acquire everybody's private property.
Purpose of 39B.
Lordship.
What if we read 39B like you want us to read?
Lordship.
Purpose of 39B.
Lordship, there is.
Purpose of 39B.
Lordship.
What is the purpose, if we understand?
Lordship.
To remove equality.
Lordship.
To have a fair, equal distribution.
Absolutely.
Even if 39B is not there.
Lordship.
Or
Lordship.
we agree with the interpretation you want us to agree with.
Lordship.
It does not include private property.
Lordship.
How will you escape 38 clause 2? The state will still have power to do what it can under 39B.
Certainly. I have no difficulty. I am not at all suggesting for a moment
But even see argument we don't.
Lordship, in fact, my lords, what my lords has raised is precisely the point I wish to raise. It is of seminal importance how my lords interprets 39B. Power, it's a duty. The power or duty under 39B must be exercised consistent with the rest of the constitution, including various restrictions on the powers of the state legislature or the central legislature. My lords, I have no quarrel, no difficulty that state can acquire any land for public purpose, use it for various. But 39B is not saying you shall go and acquire all private properties and redistribute it. That's not our constitution. That may be a Marxist constitution. Our constitution is you can acquire it. 300 capital A exists. 39B has to be read in accordance with 300A. If my property is taken, you must give me proper compensation. You cannot give me an illusory compensation. So 39B duty, please use it for common good, no difficulty. But you can't say I will take it from one party and give it to another private party. That's not the intent of 39B.
How is a cooperative society a private party?
I'll come to the Act itself in a minute, because Act, there is Chapter 8 and Chapter 8A. In fact, 8A has come because of failure of the state. I'll just indicate that in a minute.
So if we don't accept
Lordship.
the interpretation of 39B, which has been placed by Justice Krishna in Ranganath Reddy's case,
Lordship.
that would not render the Act ipso facto unconstitutional.
No.
It's just that the Act would then have to withstand the scrutiny of Article 14 and 19.
I'm grateful. That is all I was trying to say. That the power to pass legislation is there. It must meet the rest of the parameters of the Constitution, 14, 19, 21, 300A, and there are other provisions that we are relying on. Now, only benefit was under 31C, you have an additional protection. 14, 19 are out. 21 and 300A is still available. Now, that little protection goes away. That also, after Coelho, we don't know how your lords, my lords, will take that view. What is the scope of challenge under 1419 also? That we'll see separately. But under only Article 31C, if 39B is sought to be subserved, only thing Article 31 capital C does is remove the challenge under 14 and 19. Rest of the challenges still remain.
We say that you have no protection of 31C.
Lordships.
Because there's no nexus with 39B.
Lordships.
The law has to then meet the pass muster under Article 14 and 19.
Lordships. The 1419 is Lordships, absolutely. But even without that, I still have 21 and 300A. And after KT plantation,
say in Ranganath Reddy's case,
Lordships.
that Article 39B was not applicable. What was the reason given?
Lordships, I can.
That is reversed by the Supreme Court.
Lordships. So,
Why did you say that?
Lordships, I'll take out the High Court judgment. Supreme Court simply says that you have a power to acquire. That has nothing to do with 31C. You have to meet two requirements and two requirements alone. Public purpose, fair compensation. High Court, having upheld all this, should not have interfered. And that's the majority judgment. Therefore, my test of your power to acquire property will be 2 and only 2, nothing else. If you meet this, then all these 14, 19, 21 challenges fall apart. You don't have to go there. That's what the majority says. So it says once I find reasonable compensation and public purpose, it is valid under 14, 19, 21 straight away. All this is all irrelevant. Therefore, we uphold the law.
So they down.
Lordship.
Nationalization of
That's the High Court.
That's the High Court.
Ladyship is right.
The ground that Article 39B was not applicable to the exercise of power.
Lordship.
Not to that legislation.
Therefore, if my lady permits.
Reasons given for
Absolutely. Is this the High Court judgment?
Anything else? No?
Yes, just one more point. About the legislation, there are two chapters, Chapter 8 and 8A, and that's a little important. 8, cess was imposed from 76 onwards by MADA. The board was set up. 10% I had to pay, that's the landlords, 15% by the tenants of the circle rate. So even if I'm getting some 50 rupees or 100 rupees rent, I have to pay cess on these properties from 76 onwards. And the reason for the cess was that MADA will collect the cess and repair all these buildings because I'm not giving you rental. I hope I'm making myself clear. And therefore, Chapter 8 put the obligation on MADA to find out are the properties dilapidated. MADA was given huge chunks of land. They have some 2,000 acres, if I remember correctly, of land given. MADA had to carry out these repair obligation, taking money from me. So 10% of circle rate I pay, 15% tenants pay. MADA collects that money. They have to come on a yearly or whatever, a certain period, they have to come and check the value, the strength of the building and whether it's dilapidated. It was MADA's duty to repair and then give it back to the landlords and the tenant. MADA, and those reports are also on record, MADA comes and says we are incapable of doing this, although we'll continue to take the cess. That's why these are category A cess building. So they keep taking the money and say we can't do anything. And then they say, because I have failed, now I will give it to the tenants. That's what has happened. And now the requirement of dilapidated is gone in Chapter 8A. So any building, 70 occupiers may not even be tenants. Occupier definition is something also very challenging. Go ahead and say now whoever some trespasser is sitting there, he's part of 70%. He'll come and say, I wanted your building. You spent a lot of money despite no rent. You kept it up. It's in great shape. But I want it. I will take it. That's Chapter 8A. My lords, in fact, the purpose, if 39B there was a purpose, Chapter 8 satisfies that. Namely, MADA has to spend money which they recovered from us to maintain the building. That would be public purpose, no difficulty. Now what they're doing is we are incapable. They have given a report saying we are incompetent and incapable, and I mean, my word's not there, but they effectively say that, and say therefore you allow them to take over. So that's the situation. Therefore, Chapter 8, I can understand, says subserve public purpose, we will repair if the landlord is not doing. And this whole situation is created by freezing the rents. Now, if you give me freezing, even if you froze the rent, if at least you had given me the ability to raise the cost of my repairs, I would have carried out. You block me in every way, then you charge me cess. So I'm getting almost nothing by rent. Then I'm paying 10% of circle rate to the government for repair of my building, and then you say now repair or not, let the tenant take it away. Now, can an act of this sort be protected by 39B? My submission is no. 39B has to subserve the public good. Public good will be, I can, Lord, the Chief Justice mentioned, if you want to protect buildings, I understand. Now, does 8A say that only dilapidated buildings will be taken over? No. They say any building that the 70% of the tenants want. Now, therefore, it doesn't even subserve any purpose. What is happening is just unfair. For 85 years, my rents have been frozen. I am obliged to keep my building in maintenance and good repair, but I'm not allowed to collect the money. And in addition, I have to pay the cess. And MADA says, I can't repair it, so now give it away. Now, these are all hard-earned money. All the reports, in fact, when we go to the smaller bench, 5 judges or wherever my lord send us, we'll point all this out. Their own report says, most landlords have put every bit of their hard-earned money to make their house. They were relying on the income of this house to sustain themselves. Most of the landlords, specifically these buildings that we are concerned with, none of them can fend for themselves. In fact, the landlords here are the ones who are poor because they do not have even access. Yeah, but I said this is what I'll be arguing, so I'm entitled to say that. So therefore, I'm submitting that we will be submitting that in fact the 39B purpose is not subserved in any way. This is your, so to say, conduct, and if I may use the word politics of the state, that has created this situation where you're punishing me for your own failures. You are unable to, and there are the presidential assent that the respondents so strongly rely on. The presidential assent says, I'm giving you this assent on the assumption that you will raise rents in future. This honorable court in Malpe Vishwanath Acharya said that you will raise rents in future. There is a model, the union government, the parliament has passed the Model Rent Act, which says over a period of time for these old Rent Act provisions, over a period of time, the rents will be increased so that over 10 years, 5 years, you bring them in line with the present rate. Now, making this MADA, it will be completely unconscionable to allow a law of this sort where the failure is of the legislature not taking care of the situation, not taking care of the problem, and their own default they want to correct by taking away my property. That's the situation. Can it at all be covered by 39B is our submission. And therefore, once you see 39B in the context, namely directive principles obligations of the state. These are not my obligations, they are your obligations. And you're in breach of your obligations under Chapter 8. And having failed in your duty to maintain these buildings, now you can't trust Chapter 8 ends, and now you 100 times monthly rent, not even yearly rent. 1 month's rent, 100 times, so 50 rupee rent, give 100 into 50.
40.
Correct. Rent is of 1940, I'm obliged. You pay 100 times 1940 rent, and we put all the wholesale price index, etc. The prices, just the inflation has gone up more than 1000%, or 1000 times or something. And of course, the rental prices have gone up. And this is, in fact, and my lord, the Chief Justice, I had to respond to your question. All the reports of the government, respondent state government, say that in fact all these provisions are the one affecting the housing stock in Bombay. Nobody is ready to build, nobody is ready to maintain, nobody more supply is not coming, because you've created a situation which is unsustainable. So to answer the question, and of course we'll take that later, but to answer the 39B question also, these acts, these which are under challenge, are the cause for the problem, they're not the solution. In fact, if they act reasonably, make proper changes, etc., the housing stock will increase, the tenants will have the money, landlords will have the money to repair them, keep them in good repair as they do it in other places. And therefore, just to summarize and conclude, my lords, our submission is 39B must be seen in the context of the entire constitution. I have all various other rights in the constitution. My land can be taken over in certain cases, no difficulty, but you must comply with all other requirements of the constitution. By this method of 39B, you say, now I want to distribute your land to some other private party and I've taken it. That's not the interpretation that a constitution like ours can sustain. It must be, it may be in a Marxist constitution, certainly, you take everybody's land and make it a communal land. And that's the Marxist theory. Certainly not under our constitution, which still has 300A, which possibly might be a higher right than the rights we had earlier, because now the right to property in KT Plantation judgment, my lords have actually said that the 300A is now a higher right. It cannot be suspended at all. You cannot give illusory compensation. You must give a fair and reasonable compensation. You must have a public purpose. Then you can acquire a land, no difficulty. But therefore, I submit, my lords, in conclusion, that 39B, please interpret it in a manner that subserves the purpose of the Constitution. Read it holistically, read it all the provisions of the Constitution. And certainly the only conclusion that can come is this is a duty of the state. It is not the power to take away a private party's land and give it to another. So that's with that, my lords, I'm deeply grateful.
So we'll have to say what?
That extent.
That extent.
Lord, before we had divided the work, Lord, I had myself prepared a small note on this aspect. Lord, I've taken the liberty of having it uploaded. But my Lord, may I first address your Lordship on two aspects?
Yes.
Or may I address your Lordship on two aspects before going there? But the first is I want to make some arguments in support of what my learned friends have said. Lord, the second is I want to argue a point on demurrer. Lord, I want to argue a point accepting that theoretically and academically it is possible that property could form a part of 39B, but that if you accept that, the distinction between private property and public property must effectively be at vanishing point. Lord, so I want to address that second argument before your Lordships as well. So not these two. Lord, I believe, Lord, that no real reading of the directive principles chapter can really be understood, Lord, without a preface. Lord, as your Lordships are well aware, Lord, that at the time of the Constituent Assembly and the formation of the Constitution, Lord, it was always envisaged that directive principles would be very much on the same footing as fundamental rights. Lord, the often colloquialism which is used is to say that fundamental rights are somehow superior to directive principles.
I just said that these are two wheels of a golden
Exactly. And therefore, my Lord, it is always a matter of balance when we go to the directive principles, they've always got to be balanced with the other provisions in the Constitution. But I think it is also important to remember, Lord, that till 1978, we had the entrenched fundamental right of property, Lord, which was in 19(1)(f), Lord, and 31, which took into account the concept of eminent domain, or that if property is to be acquired, it could be acquired, Lord, only for a public purpose and upon the payment of fair compensation. Now, Lord, that came to be deleted for entirely different reasons, Lord, in 1978. But when your lordships look at 39B, in my respectful submission, it is important to bear in mind that that is how the Constitution first looked. So on the one hand, we had the right to property. On the other hand, we had what was undoubtedly a social charter in the need, to my Lord Justice Dhulia's point, to alleviate inequality and to distribute property. And any construction that we arrive at of 39B, in my respectful submission, must take into account this context. I'm not having said that, Lord, may I request your lordships just to see the section with me for a minute. Lord, I just want to point out to your lordships that there are three material parts of the section. But the first is what is to be distributed. Lord, is the ownership and control of what is to be distributed. Lord, is the ownership and control of something else. So there are two particular indicia of that something else which is to be distributed, ownership and control. And what that is one compendious composite expression, the material resources of the community. Not the latter part is that the distribution is to subserve the common good. But that's not so important for the purpose of the current reading. But Lord, it is my respectful submission to your lordships that, Lord, on my demurrer argument when I address it, that my Lord the Chief Justice, Lord, was not entirely wrong. Lord, I think, Lord, it would be futile and academic, Lord, to try to oppose a conceptual argument that it is possible that private property can be introduced into the concept of material resources of the community. But the real question to my mind is, what is the nature of that private property that will fit within this compendious expression, material resources of the community? But we know that it must have certain characteristics. Because it must be material resource, and what I have some definition to show your lordship of that, and it must be of the community. So, Lord, my learned friend's point, Lord, my learned friend's fees from today's appearance, your lordship said distributed through taxation, separate provision for that, Article 265. When my lady spoke of land acquisition, separate provision from that originally. My Lord, and interestingly, in Bhim Singh Ji's case, Lord, there was a challenge actually to the Urban Land Ceiling Act. The challenge was on the 39B grounds, and actually it was negative on the grounds that the 31C protection was available on the ground of 39B, as I'll show my lady also from the High Court. Actually, Justice Untwalia's judgment refers also to the challenge in the High Court, which I'll just show my lady in a minute or so. But not to come back to this point. What if we acknowledge the fact that private property can fit within the expression material resource of the community, it must satisfy all these requirements. It must be private property which has the characteristic of being a resource, and it must be a material resource of the community. Now, my Lord, having said that, my Lord, may I show your lordship my note? My Lord, I've made some submissions in my note, and Lord, please bear in mind, my Lord, my note was slightly focused on a different point, and that's reflected in the chapter, but it really addresses this point. Lord, or it is in the morning Google link at 9 o'clock or so, which was sent to your lordship. It's called Chapter 8A does not receive the protection of the. Sorry, just now. Okay. Thank you. Your Lordship, have it. But para 2, Lord, but para 2 is what I've already, in fact, Lord, made some submissions to your Lordship on. But can I take your Lordship straight away to paragraph 4? Yes, please, Lord. Yes, my Lord. Yes, page 48, that's right. But and if I can actually, my Lord, to my Lord the Chief Justice's point, para 2 actually, my Lord, states it a lot better than I said it. My Lord, may I just read it to your Lordship? Or paragraph? Sorry. My apologies. But can I just read to your lordship paragraph 2, my lord? Lord, state policy in Article 39B has 3 ingredients. There must be a material resource. More importantly, it must be a material resource of the community. To my Lord Justice Bindal's point, but something which I'll just develop. Lord, if the material resource is not of the community, it is not the subject of the policy. There must be a distribution of the ownership and control of the material resource. Article 39B does not say that the material resources are to be distributed. Mere distribution of material resources without distributing the element of ownership and control is not the subject of policy. So, my lord, the distribution, as I mentioned to your lordship, my lord, is with regard to ownership and control. The distribution must be such as to serve the common good. Distribution which does not subserve the common good is not the subject of the policy. My lord, I'll then skip minimum of this. My lord, please come to paragraph 4. Now, my lord, some dictionary meanings, well, because we don't have any actual legal construction of these terms, but material resource. The dictionary meaning of resource and resources is a means of, your lordship, sir, it is a means of supplying a deficiency, a stock or reserve, which can be drawn or when necessary, available assets. In plural, the collective means possessed by a country for its own support or defense. Example, countries with large natural resources. So, my lord, that's the definition, my lord, with regard to resource. It's normally used in the context of community. And, my lord, sometimes in plural, it is used in the context of state property. But it doesn't preclude it being also of private ownership, as I'll come to. My lord, resource, something which lies ready for use or that can be drawn upon for aid or to take care of a need. The plural is available money or property, wealth and assets. The plural is something that a country or state, etc., has that can be used to its advantage, natural resources, including coal and oil, a means of accomplishing something, and that's what Webster says. Now, Lord, Article 39B uses the plural resources, which brings in the national or community aspect of the meaning of resource. That this meaning in Article 39B is evident from the qualification of the community in the article. The meaning of the word community itself is a body of persons. The word material as an adjective in this context means important and essential. Material resources of the community can therefore mean natural resources, illustratively, or which are those of the country or the nation, or the means of production, which in a large sense can be said to be of a community, even though they are in private hands. The concept negatives any property in which there is no interest of the community. Lord, in Karnataka and Rangareddy, Lord Justice Krishna Iyer cites the meaning of resources from a dictionary, from Black's dictionary, and says this. Lord, money or any property that can be converted into supplies, means of raising monies or supplies, capabilities of raising wealth, or to supply necessary wants, available means of capability of any kind. This definition is no longer found, Lord, in the dictionary. It's not available. By itself, this definition cannot be applied to the concept of 39B, as it does not bring in the interest of the community as a resource. But then I've cited, my lord, the observation which your lordship already read. I've pointed out that it has been followed elsewhere. And more in 4.10, Lord, what I've said is this, Lord, this formulation of material resources is too widely stated. Private sources of meeting material needs are not material resources of the community. Not everything of value in the world is a material resource. The Constitution does not embody a political or social theory that because the individual is a member of the community, his resources, however small and humble, are necessary part of the community. So, my lord, that is, my lord, an interpretive argument, my lord, based on this aspect of the matter. Lord, just one last point that I have for your lordship. Lord, to become a material resource of a community, a particular class of property must have some homogeneity, or it must have some common characteristic. Not the housing stock that is under rent and subject to MADA acquisition is of the most diverse and varied kind. Lord, if your lordships were to go to Bombay, my lord, to perhaps what is the most affluent area of Bombay, Carmichael Road, your lordship will find, Lord, extremely wealthy people living in lavish style in, Lord, well-appointed buildings. Or on the other hand, if your lordships were to go to some of the ghettos of Bombay, your lordship would find people almost at the point of destitution who are also tenants. My lord, so the housing stock lacks a quality of homogeneity. But it is not possible to say that in every case, the housing stock which is the subject of acquisition under 8A can have a homogeneous nature, and therefore, in my respectful submission, can never fall within the definition of the material resource of the community. I'm obliged, Your Lordship.
Thank you.
See?
My lord, before coming to this, you want material resources. I will go to this Article 366(12). Goods, where the definition, because if we have to enlarge the definition of 39B to include everything, which will include a good also, all material, commodities and articles. It means by way of this interpretation, all material resources are different than the goods. So therefore, now the advancement of the Constitution of India and amendment, now kindly have 17th Amendment, because the right to property was always a thing which was being taken away. Now the 17th Amendment, when came to 31A, when the provision was made, if you have to take the property of someone, make the payment at the market value. That was 17. Therefore, that comes the 44. And the third one comes the 73rd Constitution Amendment, which has made the country three-tier system. And in relation to that, I will be making my submission. My lord, may kindly have 31A, only to the extent of market value. 31A proviso. Provided further where any law makes a provision of acquisition of a state, comprise is land, personal cultivation, whatever. We know that urban land ceiling has gone. So there is no, because when we go to the Keshwanand Bharati, that was the concept of creating a new public order or social order. Now with the advancement after 75 years, we are into a different era, and we have come from private type nationalization to disinvestment. So the meaning what was there, because at that time when we interpreted these laws, Article 31 was there. After 44th Amendment, Article 31 has gone. And that time, 19(1)(f) was there. Right to property was a fundamental right. After that, now it is Article 300A. So that, to that extent, kindly have 17th Amendment, which says you cannot, you have to pay the market value. Now, after that, my lord, kindly have the Article 243G. Because after 73rd Amendment, the power has been entrusted to the local self or the public good, the public of the managing the utility or any good. To that extent, my brothers who have placed the subject. Now, two chapters have been added, Part 9 and Part 9A of the Constitution of India. Power, authority, and responsibility of Panchayat. This is for common good, not by giving it to the hand of certain number of persons by acquiring. Now, my lord, I pause for a minute. My lord Justice Manoj Mishra is there. My lord Justice Dhulia is there. And even I have done some cases where the properties under 20-point program were given to certain persons. They paid some money by getting it transferable right and they sold it. This is the hard reality of the era. Kindly have power, and I'm coming to these two point A or B, subject to the provision of the Constitution. The legislature of a state may by law endo panchayat such power and authority may be necessary to enable them to function the institution of self-government, and such law contain provision of devolution of power and responsibility upon panchayat to appropriate level, subject to such condition as may be specified therein. Preparation of plan for economic development. This is 39B. And social justice. Second part, implementation of a scheme of the development. What has been done in the state of West Bengal, retrospectively from 1969, in the year 1981, definition of land has been enlarged to include mill, factory, even the religious institutions have been brought in within the definition of land and apply with that. So to that extent, what I respectfully submit, whenever 39B comes, there has to be a distribution by whom? Now I, in the backdrop of this, I read Article 39. And then I will come to the Schedule 11 and 12. In Bombay, the Act, one of the feature is the slum, which comes under Schedule 12 in the Constitution of India. So we are interpreting because in Sanjeev Coke in para 20, this honorable court said, you cannot take the under 39B, you cannot take the entire industry. There is a clause. So therefore, you cannot make a person without livelihood. Now concept is this, I will read two paragraphs, 239A, B, the ownership and control of all material resources. If the material resources is a good, then the material resources is something different, which is to be used for a common public, for a common larger benefit and interest, not for the merely purpose of living or housing or just for the purpose of making the social standard. It is something very, very, very big step, which has to be, because at the time of the nationalization cases, certain companies were in the hand of Britishers.
What is the point that you are trying to?
I'm saying it now. What I submit, number one, material resources is a word which is to be used in a very careful manner to include only the resources which are essential to the society and not the private properties.
That point has been made.
Made. Now, two, concentration of the wealth. Concentration of the wealth, not by taking away the right of a private person, depriving his right to livelihood and give it to someone else. Applying the ceiling limit or applying a house or taking away the right of a livelihood of someone, the concentration, suppose in the West Bengal, the ceiling limit has been imposed with effect from 1969. Now, after that, the ceiling limit with the retrospective effect, our houses and property, mill, factory, everything is being taken away. So that to that extent, in that context, what is the concentration of the wealth? Now, in my written submission, I have dealt with the definition part. I leave it to that. Now, second submission, which I am going to make, my lord, 300A, right to life, with the right of livelihood, and 300A, because now it is a constitutional right. Now, constitutional right is a right after the advancement of so much of the jurisprudence of the property, it cannot be taken away on the name of merely concentration and applying the yardstick, which was in the year 1971 or 72. For that purpose, I merely read one paragraph from Sanjeev Coke.
What is the point that you are making now?
Now, the concept I'm making, this honorable court never approved that the state has the power to acquire everything at their own. 39B, rider came in Sanjeev Coke. The Learned Council, page 2317. The Learned Council submitted Article 39B would be attracted if the industry as a whole is nationalized, not if only a part of industry. According to him, all the coke, own plant, whatever, they existed to be nationalized. but no privately owned property. We are unable to see any for the distribution between public, private and joint sector range of any nationalization state policy inherently inappropriate subject. Scales of justice are not designed to weigh competing social economic factors in such a matter. Legislative wisdom must prevail with the judicial review must abstain. To that extent, what I respectfully submit, the right to property, which is which is now a constitutional right, does not come within the purview of material resources. That is my submission.
Property is not a material resource.
Property, if owned for a livelihood, if a person is having a property which is not for livelihood, other than for livelihood, there has to be a distinction between a livelihood of a property and a property which is not for livelihood. Suppose in Bombay, I have one house and that house has been taken away. That will not be for the purpose of common good by depriving me from my right of livelihood.
Can be. Suppose if you have a house in 200 acres, then it will be taken away.
My lord, house for my right to livelihood, then Article 21 survives.
For equal distribution.
For equal distribution, then the law has to be there that nobody can have a house of more than 50 yards. Equal distribution, including me, not by taking away my right.
Thank you, Mr. Sharma. So tomorrow morning, we'll start with the Learned Attorney General. Tomorrow morning.
Lordships, if I may just have 10 minutes of your Lordship's time.
Sorry.
Look, we just want to make very brief submissions tomorrow morning, 10 minutes, will not between the two of us.
All right, 10 minutes in the morning, and then
We'll share. Great.
The notes and compilations sent by Mr. Andarujana and Mr. Devarajana are without volume numbers. So please make sure that you put them all together in volume numbers. Otherwise, we'll never know. You can actually put yours as give them specific volume numbers and then share it with the other side, so that they will also know.
By Lord's kind permission, because a lot of what we have written, we have been asked not to get into it. Can we edit them and send it to you, my lords? Because see, we have gone on the basis that 31C we could argue. Lot of matters are related to 31C. Now we have not been allowed to argue that.
And but do it by the evening today. By 8 o'clock in the night, give it to the court master.
Good morning.
And you can send a message to the court master when you have added it. Otherwise, he doesn't know that you have added it.
I'll do that.
Right? So by 8 o'clock, make sure all the edited compilations in volume wise are available with the court master.
Please.
Yes, certainly, Mr.
Grateful.
Obliged.